Many thanks for joining this webinar about workplaces and internationally mobile workers. It's being brought to you jointly by BDB Pitmans, lawyers, and James Cowper Kreston, accountants. We're joined on the James Cowper Kreston side by Charlotte Firth and Jaouad Chakht, both senior managers for global mobility tax, and Claire Wagstaff on the BDB Pitmans side. I'm sure many of you may already know her. She's a legal director in our employment team. And for those of you who don't know me, I'm a partner at BDB Pitmans and I specialise in immigration. Now we have decided to do a joint webinar between lawyers and accountants in this particular case, talking about mobile workers, because legal and tax and accountancy issues are fairly intimately interwoven as far as mobile workers go. It's often the case that we here at BDB Pitmans are asked to provide advice on staff that are moving to and from the UK, and it quickly becomes apparent actually that there could be tax or social security issues that arise as a result of whatever move is planned. And that's where we usually bring in outside tax and accountancy expertise, and I'm sure it's the same in the accountancy world, that when you're putting plans together for a client that wants to provide agile working solutions for staff or send them overseas, questions arise about the legal mechanics of doing so. And those types of situations have begun to crop up far more frequently for two main reasons. The first is the huge increase in remote working over the past year, with many businesses forced by the pandemic to have staff at home. And that's led to many overseas national employees as well returning home, either because of choice or circumstance, and even UK nationals are counted among those who have taken the decision. I'm sure you've seen the reports in the newspapers to work overseas or somewhat more attractively for the headline writers from the beach in Spain. But in fact, the reason why my background is blurred is to hide the sand dunes and the deck chairs in the background. So that's the pandemic on one hand. The other, albeit to a lesser extent, driver of remote working is Brexit. The end of free movement has led businesses maybe to reassess the need to have staff in the UK, given the hoops that now have to be jumped through in order to bring staff to the UK and the potential cost of doing so. And those that do still want to recruit from the EU now have to be familiar with the immigration issues that moving those staff to the UK now involves. And conversely, sending UK staff overseas, even for short-term postings, now is not so straightforward now that free movement has ended. So what we're going to do is to walk you through a few of the tax and legal issues that might arise as a result of the increasing mobility and internationalization of the workforce. So first, Claire is going to highlight some of the employment issues that might crop up. I'll touch briefly on the immigration issues, and then Jaouad and Charlotte are going to focus on the tax and social security side of things. I'll try to keep some form of track on questions that come in. What you should do is use the Q&A tab at the bottom underneath the presentation to put any questions that you have that you wouldn't mind us answering. And for technical queries, if you use the chat function. So if you're having problems hearing or anything to do with the sort of technical side of things, use the chat function. So without further ado, I will hand over to Claire Wagstaff, who's going to talk about some of the employment issues.
Morning, everyone. So as Tim mentioned, I'm going to be covering the employment side of things. So if we can have the first slide for employment. That would be great, thank you. So I've set up here briefly where the requests to work abroad or return to the UK may come from. They may come from employees on a temporary short-term basis, to visit family perhaps they haven't seen for 18 months, extended holidays, maybe stay a little bit of time in holiday homes. There may be longer periods that people request to work from abroad for. For example, Barbados allow nomad visas for 12 months. There may be permanent requests to change the place of work, as Tim said, people moving backwards and forwards because of Brexit. Then there may be requests from the employer side of things as well, so moving offices and things. So a range of options that an employer might face, and it may be a sort of informal agreement with the individual and the employer, or it might be a formal request under the statutory provisions. The statutory provisions are restricted in who can reply, the number of requests that can be made, and also the reasons why an employer can refuse a request. And they focus on things like quality of work, reorganising of work, additional costs, being able to make the customer demand, meet the customer demand. So they can be quite restrictive for an employer, especially in these current times where employees have perhaps been able to show that they can still perform their work as normal, but that's there in the background as well. So if we move on to the next slide, looking at the factors to consider for moving staff abroad or bringing them home, there's a few practical things here. For example, is there a time difference? If someone's moving to America, are they going to be logging in America time or UK time? How does that fit with the rest of the team? Do you need to set some core hours when you agree these types of things? How are they going to be supervised, trained? All these factors that perhaps need to be considered as part of the move. Also, how long is the request for? We'll see that temporary requests are perhaps viewed differently when it comes to visas and tax and social security compared to a longer move, and it's always a good idea to factor in flexibility, review operations depending on the business needs as well, and making sure that that's all documented with the individuals so that everybody is clear exactly on what is intended. Similarly, can the work be done lawfully and efficiently from the requested place? Can the business cope without the person for the specified time? There may be restrictions on FCA regulations, on being able to be supervised abroad, or board meetings taking place remotely. So lots of different factors there to consider as well. Then we have the health and safety risk assessment side of things. An individual will still need to be able to work. So they might have a laptop and a mobile phone, but they might not have a desk and chair set up abroad. They might not have the 2 or 3 monitors that they're used to. So again, how is that going to impact on their work? Who's going to pay for this equipment? Making sure it's all returned if they do leave. Then we've got additional costs of things like visas, health insurance, if that needs to be taken out separately, who's going to bear the cost of that? If they're making international phone calls, or are you going to say that they should be using Zoom or Teams? Internet costs, complying with any travel requirements, if they've got to isolate in a hotel, who's going to pay for that? And then any additional tax which might arise because they're now changing location as well. Visa questions about how long can they work for, how long will it take to come through, holidays and benefits, are they going to keep the UK bank holidays, or will they be benefiting from the holidays of their new place of work? Security, so is the network secure, is any personal data being transferred, how does GDPR kick in as well, and any intellectual property issues? Is there a policy? It may be a one-off query, but you may find that actually more and more queries are coming through, and rather than having to remember to go through these points with each individual and making sure they understand them, maybe a policy underwriting all of these issues could be put in place. And then also looking at existing insurance policies for remote working. So the employer's liability insurance, the individual's home insurance, are there any restrictions there? And similarly, what insurance may need to be put in place if they move abroad or come back to the UK. So if we now move on to the next slide, I've set out here some risks to consider as well. The usual protected characteristics under the Equality Act continue to apply. So you can't treat employees less favourably because of sex, race, age, disability and nationality. And nationality may be a factor here if there are employees wanting to return home or move different countries. And there are various implications which may be why an employer can perhaps agree to some moves but not to others. Not only the tax and visa side of things, but perhaps health guidance, politically what's going on in the country, also the well-being of the individuals, health and safety, data protection, intellectual property. So there's a whole host of things that may explain why perhaps some individuals are able to move, and it's not necessarily a favoritism for nationality, but what else is going on with these factors that the employer has to consider. If it's not possible for a flexible working process to be agreed, perhaps there may be other ways to support the individual wanting to spend that time away in a different country, maybe unpaid leave, period of sabbatical, but it's really a case of discussing these things with the individual perhaps and seeing if you can come to a working solution. As I say, most or many employees have been able to show that they can work remotely alongside other commitments. So it may therefore be more difficult to say that providing the quality of service isn't able to be provided if they are working remotely, but the employer will still need to consider, as I say, all these other factors as well. And it is important that prior approval and agreement is made and reached between the individual and the employer, and it's always a good idea to put these things in writing so that everyone is clear exactly on what's happening and the intentions, and given some time to check with local advisors in the country as well as specific tax and security advice. So if we move on to the next slide. So in terms of the place of work and what laws apply, the starting point would be the contract of employment. That may have a jurisdiction clause that says it's governed by the laws of England and Wales. And the UK has quite favourable rights, but it's possible that some employees may want to rely on the jurisdiction that they're in. For example, if they give more favourable holiday or better protection from dismissal. So then it's a question of looking at the underlying employment relationship and where the strong connection may lie. If it's a temporary move, then it's potentially more arguable that the connection still remains with the original country, perhaps that's where the individual's home is. They consider themselves going back to the original country, and therefore that's where the connection lies. And there may become a point where actually your place of work does change and the intentions do change. And so it will be a question of fact to consider. And the factors to consider, as I say, are where the employee is based, where the employer is based, where their home is, whether they do actually work elsewhere or whether they are now based in that other country, how they're paid, if any bonuses are based to the place of work, how they're managed, and how any disciplinary and grievance decisions are made. It's not possible to contract out of any chosen system of law. So even if the contract does say it's governed by England and Wales, if over time it looks like they've actually moved to a different country, they're connected there, they have very little connections with the UK, then it may be that actually in practice it's the jurisdiction of the new country which can apply, and their rules and regulations and protections which would then kick in. There has been a case recently where an individual started working in Africa, they had a student visa to go to America, they then went to Switzerland, and then they came to England to work and were trying to get a visa in the UK. They were dismissed and they wanted to bring discrimination claims based on things that happened in Switzerland, the UK and the US. And the tribunal had to decide, well, you started as a US employee, you then moved to Switzerland and you've been in the UK for a while. At what point can we say that that connection to the US is ended and you're now actually covered by the English and Welsh law? And that's quite important when it comes to things like time limits for discrimination, as to whether they can look back over their whole employment history, despite it being in the different countries, or is that just the background factors, and really it's only perhaps the most recent time that is covered by the jurisdiction of the country that they have ended up in. So that's the employment side of things. I'll hand over to Tim now to cover off some immigration side of things.
Thanks, Claire. That's really interesting, actually. There's clearly a lot for employers to take into consideration on the employment side of things, and it's good to have that sort of list of factors which you may or may not have considered when you're dealing with remote workers who may go overseas. One other thing that you may not have considered as employers is the immigration side of things. And it might simply not occur to you to ask questions about immigration status and right to work when people go overseas. It goes without saying, as I mentioned in the introduction, that since the end of free movement at the beginning of this year, the end of the transition period, British nationals have to have immigration status in order to work in an EU country. And it's possible that they might not have thought about that, even though obviously Brexit is quite a well-known phenomenon, or they might be intending to work on a remote basis just temporarily, on the basis of a visitor arrangement. Think of our lucky individuals in the press who've been working from Spain, and perhaps they did so simply on the basis of visa-free travel and hadn't taken into consideration that actually there might need to be some kind of immigration permission in place at the other side in the place of work. So you've always got to ask yourselves, is it legally possible? So let's take Spain as an example. If a UK national goes there at the moment as a visitor, they are restricted to a certain range of activities that's fairly limited, and it's things like attending meetings or trade fairs or intra-corporate activities. It's quite similar to the visitor activities that someone can do if they're coming to the UK under the immigration rules, the UK immigration rules. So theoretically, obviously we're not Spanish immigration specialists, but working remotely from Spain or wherever it is may risk a breach of Spanish immigration law. That's probably unlikely that an employer will be implicated in that kind of breach of immigration rules, but frankly, it's best to avoid that kind of scenario. And as Claire was saying, to discuss the plans with relocating employees. So what about non-UK nationals? Well, again, they may still need local visas, depending on what nationality they are, where they're locating to. So again, it's something that needs to be taken into consideration. Perhaps more importantly, what about UK immigration status? So if you have UK workers currently located in the UK, if they currently have status in the UK, the question is, will they lose that status whilst they're abroad? So if they're currently sponsored under the points-based system, or they have some other kind of visa under the immigration rules, will their visa expire whilst they're abroad? If it won't, will they be away so long that actually their immigration status might lapse, or they might be challenged by an immigration officer on return if that immigration officer asserts that actually their absence from the UK indicates that they're no longer here resident for all intents and purposes. If they have status under the EU settlement scheme, for example, will any absences affect that status? So you probably already know this, but those with pre-settled status, so they haven't got the sort of permanent right to remain yet, they would lose that after a couple of years absence. If they're away from the UK from the UK for a couple of years, that would lapse. Those with settled status, slightly more favourable position, they would lose it if they were outside of the UK for 5 years. But those with pre-settled status and other kinds of immigration permission under the immigration rules need to be careful about their absences, because if you do want to move from pre-settled status to settled status, then absences over 6 months in any 12-month period will normally have the effect of breaking that continuous period of residence. So that needs to be taken into consideration. There's a certain amount of planning that individuals will need to do if they have status in the UK in order to safeguard that status. So if they do go overseas and they come back to the UK, under what permission are they doing so? Is it a continuation of the permission they had before, be it under the settled status scheme, be it under the points-based system? Are they coming back as visitors? And again, if they're doing so as visitors, are they doing activities that are permitted under what's, well, Appendix V of the immigration rules goes into the permitted activities that people are allowed to do in the UK as visitors. And again, it's quite restricted. So those things just need to be looked at. And if we move on to the next slide, I'll go over very briefly, because I think this has been trailed in the media quite a lot anyway. Obviously, there's a distinction between red list, amber list and green list countries, as we all know. The quarantine, the return quarantine requirements for red list countries is obviously much more much stricter, and currently I think it's only UK and Irish nationals and those with some form of residence entitlement in the UK who can return currently from red list countries. Amber list, slightly more permissive, but of course you do have to quarantine. So as an employer, if you're moving people back to the UK currently, then that all has to be factored in. And similarly, staff may have concerns, or you may have concerns as an employer, if you're sending people overseas, or they're working from overseas in other countries where the risk of COVID-19 might be higher. There might be a health and safety concern there, that be it COVID or not related. And of course, there's the issue of data protection as well. So not just safety, personal safety, but also the issue of data protection. Are you covered as a business in terms of the information flows that are going from and to your worker who's located abroad? So if we go on to the next slide, I'm going to go over very briefly those UK staff who are delivering services overseas. Now, I won't go into this in too much detail because it might help those of you who suffer from insomnia. It is, yes, the UK, or the EU-UK Trade and Cooperation Agreement. This is the big trade agreement which was signed just before Christmas, and it governs lots of things, but it also is quite important in terms of regulating the activities of what your staff can do when they're delivering a service overseas. So if you have a UK business and you have an EU-based client and you want to send UK staff over to perform that contract overseas for a limited period of time, then you need to either be familiar with the EU-UK Trade and Cooperation Agreement, the TCA as I'll call it for short, or you need to seek advice, because what it provides for is contractual service providers or independent professionals. So contractual service providers can be your staff who conform to various requirements. If they have a university degree and have been working for you they have 3 years professional experience in what they're going to do in that country, then they can come under the provisions of what are called contractual service providers, and they can go to the EU country, but it's subject to lots of caveats per country and per type of service. And you may need to get a visa under the contractual service provider requirements once you land in the country where you're providing the service, or where your contractual service providing staff are providing the service. So you definitely need to look into that if you are providing a service overseas. And conversely, if you have people coming into the UK, there is a provision in the immigration rules, which is the bottom bit on that slide. It's called International Agreement Tier 5, and this basically allows you as a client to sponsor contractual service providers into the UK to provide a service in the UK. So they're quite complex and new rules. So if we just move on to the last bit that I'll say about immigration, which is on the next slide, and that is the new points-based system for overseas nationals, which now, of course, after the end of free movement, includes European nationals. And it is really a sea change in the way that we think about employing and recruiting individuals from the EU. Again, in the line of remote workers, if we are bringing people into the UK from the EU, there is now quite a large cost and administrative element to doing so, because invariably, unless people have permission to be in the UK under any other personal rights, then they would need to be sponsored. You would need to be registered as an employer, and you'd need to sponsor people into a job as skilled workers. Now it's much more flexible than it used to be under the old Tier 2. Anyone who's familiar with the Tier 2 sponsorship system, it was quite regimented. You used to have to advertise for most positions to the resident labour market first. It's been streamlined and simplified lots, but there is the disadvantage that, of course, EU nationals now are required to be sponsored into the UK. So I think the next slide will just go into a few specifics of that sponsorship system. So you've got to have a job offer in an eligible job occupation. People have to meet the English language requirements. The job has to be skilled to a certain level, and you have to earn minimum salary requirements in the UK. So that's all I will say about the immigration side of things. I'll now hand over to Charlotte.
Hi, Tim. It would be probably me right now.
Apologies.
No problem. Good morning, everyone. I think Charlotte and myself, who work at James Cowper Kreston, will today just cover the tax and social security implications when you want to basically send some employees overseas, or you want to accommodate employees working remotely overseas. I think we clearly noticed, like over the last year and since the pandemic, that our work changed slightly, and we advise more and more clients on the tax and social security implication in relation to employer who consider to accommodate the employee to work from anywhere. So as you can see on the slides today, we will cover different aspects of that. So the tax residency and the implications. So employer obligation under UK pay as you earn and overseas requirements. There's also a notion of permanent establishment risk and the social security implication as well that Charlotte will cover later on. So while the employer wants to accommodate the employee requests with regards to work remotely overseas, the UK tax and social security implication should not be overlooked. And the first thing you need to consider here is the employee's residence position. As you may know, different countries have different tax rules to determine the tax residence position. So you always need to seek advice in the specific country. So don't just assume that one rule will fit all countries. In the UK, we have the statutory residence test to determine someone's residence position. It is really important to understand like the residence position of like your employees, because that has a direct impact on their tax position. So the statutory residence test is actually a number of different tests which have to be taken in a specific order. So just broadly speaking, the statutory residence test has three parts to it. So the automatic overseas test, the automatic UK test, and the sufficient ties test. and someone would be considered non-UK tax resident if he meets the automatic overseas test. On the other side, he would be considered UK tax resident if he meets either one of the automatic UK tests or the sufficient ties test. The sufficient ties test determines residence based on a number of ties to the UK. For example, we go like the family accommodation, the accommodation, the work tie, the 90-day tie, the 90 tie, and number of midnights spent in the UK. And this test often catch a lot of people who do not get caught by the automatic UK test. So all this test is a bit like a flow chart that you follow through until you meet one of the tests. And once you have met one of the tests, you don't need to consider to continue. You don't need to continue any further. However, I think it's possible to be resident part through the year and basically to be resident also it's also possible in some country, like to be resident part of the tax year and non-resident for the rest of the tax year. This is most likely when someone arrives or leaves the UK part through the year. This is called being a split year tax treatment, and this is a split year residence. And there is a use of concession to ensure that income received in the other country before arrival or after departure is not taxed twice. For the tax residence position of someone, and if someone working remotely abroad, like the residence position in the UK and in the overseas countries is a main things to consider, because it is possible to be resident in two countries at the same time, and this is called dual residence, and can cause double taxation problems in both countries. So you need to, because both countries trying to seek to tax the same income at the same time. That's why we got double tax treaty between two countries which can be used to elevate double taxation by determining out of the two countries where someone is treaty resident. So it is really important to look at a specific treaty between two countries, as each treaty can be worded differently. But generally, a treaty will determine treaty residence by looking firstly on the permanent home, secondly on the center of interest, both could be financial and social, and thirdly, the habitual abode. The last point under like the double tax treaty is the nationality. Again, here it's a bit like a flow chart, and if the first criteria cannot be met, then you move to the second criteria. For example, if an individual has a permanent home in the UK, but also a permanent home in France, so basically you got like permanent home in both countries, then this criteria will not be met. So you need to continue under the double tax treaty between France and UK to see if like the second criteria, who is the center of vital interest, is met. And if it's in the center of interest is in France, basically the individual will be it will be treated as residents in France. So now we just highlight broadly like the residence position of like an individual, with like clearly the first starts when you need to look at when you have employee working remotely abroad. You need also to consider to basically make some pay as you earn adjustments to ensure that the correct tax treatment is applied on the employee who remain into the UK payroll. So when an employee, for example, is no longer a UK tax resident and work abroad, anti-tax code, no tax code are generally issued to the payroll. So for example, if you live in another country that has a double taxation agreement with the UK, then you may get a code namely anti-tax code. And applying for the anti-tax code means that the employer does not have to operate PAYE on employment income relating to non-UK duties. However, this anti-tax code is apply only for the tax and not national insurance contribution, and this need to be reviewed basically separately. And Charlotte we will cover that later on. So an anti-tax code should take effect from the departure of the individuals to prevent double taxation. So it is clearly imperative that you complete the relevant form and send them to HMRC prior to the employee commencing work abroad. HMRC has advised that just a letter including the relevant information will suffice. However, in some cases, HMRC are still requesting a specific departure form, namely the P85 form, to be completed. If we think now that the individual working remotely abroad has any substantive UK work days, for example, is coming over to the UK just to work for the company a few days or through the year. So any substantive UK duties will be taxable whilst the individual is non-UK tax resident, whereas incidental duties will not. So here we need clearly to make the difference between incidental duties and substantive duties. And HMRC will consider the quality rather than the quantity of the duties. So there is like no specific number of days before duties are considered substantive. The main rule of thumb here is that the work done in the United Kingdom is subordinate or ancillary to the one done overseas. It may be incidental, but it could be also substantive. And if the work done in the UK is broadly the same kind as the one done overseas or of equal importance, it's likely to be substantive. So if the employee anticipate or the employer anticipates that the employee will have substantive UK work days, it's clearly important to double check that, because a section 690, a section, namely section 690 agreement should be applied for the tax, basically to tax an estimate percentage of work days to be performed in the UK. And that basically generates a percentage of tax under the UK payroll, but also generate something, a requirement and an obligation to submit a UK tax return for the individuals, basically just to report the actual position. However, the section 690 does not cover employees who are treaty non-resident in the UK. So you need to be careful on the fact that if the employee is non-UK tax resident under the sufficient, for example, under the sufficient ties test or any of the overseas automatic test, or if he's considered treaty non-resident in the UK via a double tax treaty, and that will be not applicable for him if this is the case. If now we consider that someone who basically working remotely abroad for a few days, but is still UK tax resident, is clearly important to consider a scheme, a specific scheme. And under circumstances, this scheme, namely the net of tax credit scheme, could be applicable. The main purpose of the scheme is to give provisional relief for double taxation to employees who must pay both UK and foreign tax from the same payment of earnings. In short, basically, UK PAYE is deducted as normal in the UK. However, a portion of the overseas tax could be basically deducted under the UK payroll, and only the balance is sent to HMRC. So here, the foreign tax that the employee is liable to pay is deducted from their existing UK PAYE liability and paid to the overseas tax authority. So the credit available under the agreement is here restricted to the amount of UK PAYE. So if, for example, the foreign tax exceeds the UK PAYE because like the tax rate overseas is clearly higher than the UK, then no UK PAYE will be due for the pay period. The main benefit of this scheme and to the employee is that they do not suffer both UK PAYE and overseas withholding tax on the same income in the payroll. Because if we take an example of someone who is working a few days in France but remain UK tax residents, basically will be taxed in France as a non-UK tax resident, and he will suffer tax on the French work days, but he will suffer tax on the full work days in the UK. So basically on a full employment income. So without taking this foreign tax credit scheme, the employee will suffer double taxation through the year, and he can correct that double taxation via a tax return. But however, using this net of foreign tax credit scheme will allow basically to not suffer both taxation overseas and in the UK at the same time, and that basically will allow him to not suffer on a cash basis monthly by taking the case monthly by monthly, basically by deducting the overseas tax on monthly basis. Is maybe too much information here about the tax adjustments on the UK payroll, but this UK PAYE adjustment is one thing to consider here, and it is important also to not forget employer and employee obligation in the overseas location. And that's why we strongly recommend considering if the employee, for example, become residents overseas, if there is any tax return to consider and to submit overseas as well. If there is like any requirement for the employer to register locally or to operate a payroll overseas to withhold tax or social security. So these answers and about employer obligation and employee obligations overseas vary from country to country. So it is clearly important to seek local advice. And as a member of an international tax network, we can provide clearly the bespoke advice on different scenario of each individuals. Speaking now of this different tax residence position analysis, the PAYE issues to consider now is and overseas compliance, because it's like something to consider and it should be not forgotten. Now, if we move on to what we need to consider for permanent establishments when you got employee working remotely, is something that you need to take in consideration, because now, as you may be aware, if a business were to operate within another country, that country may seek to tax the profits that arise there. This could potentially arise either by having a corporate tax residence or permanent establishments in that country. While the rules on permanent establishment vary to an extent from jurisdiction to jurisdictions, typically and consistent with the OECD Model Convention, a permanent establishment in a jurisdictions arise there if there's like an entity with a fixed place of business or a dependent agency. So, for example, if you have like employees who starts working basically from another jurisdiction for a long period of time, that may give rise to a permanent establishment in the employee's jurisdiction as a result of their being considered to be a fixed place of business. Therefore, we strongly recommend that the relevant tax treaty should be reviewed as much as possible to determine the overall residency of the company based in the UK. So it is important to undertake a permanent establishment risk analysis to ensure that a permanent establishment or a corporate residency has not inadvertently been created due to the activity of some of your employees working remotely. That analysis needs to be undertaken on case-by-case basis, giving a full consideration on employees' duties and in which jurisdiction that duties have been performed. This analysis will help to reduce the risk first of unexpected underpayment, but also the interest and penalties due to the failure to comply with the jurisdiction in questions. Now we've discussed and I've just highlighted basically the different points on tax residence positions, the POA adjustments, what you need to consider overseas, but also the risk of permanent establishments. It is clearly important to consider the social security implication, and especially since the Brexit. That's why I will just hand over to my colleague, Jaouad first. Thank you, everyone.
Thank you, Jaouad. So I'm going to cover the social security considerations if you have an employee working overseas. As Jaouad mentioned, the social security position doesn't necessarily follow the tax position, so you would need to consider that position separately. And the outcome will partly depend on the country in which the employee is working, as well as the circumstances. So starting with employees working remotely in EU countries, as you're probably aware, the rules have changed quite a bit for cross-border working in the EU post-Brexit, but all EU member states have opted into the new protocol governing social security coordination with the UK, so that's good news. That means that broadly the position remains that you only pay in one state only, and that's usually the state of habitual residence. So that means that if an employee is working remotely in an EU member state and not on a temporary basis, they would usually pay social security contributions in that country. And that often requires the employer to register in the other country as an employer, and then to run payroll to withhold social security contributions locally. However, if an employee is only working temporarily remotely in the EU country, it may be possible for them to remain within the UK national insurance regime. And that's where it matters whether or not the remote work started before or after Brexit. So if the cross-border working situation or assignment started up to and including the 31st of December 2020, then the individual would be covered by the old rules, which have been grandfathered, and that means that they would be able to get an A1 certificate to remain in UK national insurance for up to 2 years. And it also means that they can apply for an extension under the old rules and to take them up to 5 years potentially, but that is only as long as the situation continues uninterrupted. So it does mean that someone could potentially apply now post-Brexit for an extension to an A1 they'd already had for the last 2 years. However, if someone is working on an assignment in the EU and that started from the 1st of January 2021 onwards, they would fall under the new rules post-Brexit. And that means that an A1 can only be granted for a maximum of 24 months to remain in UK national insurance. And then from that point onwards, if they remain in the EU country, then local contributions will be required. So that particularly has an impact when employees are working in countries with higher social security contributions, both for employer and employee. So typically that would be somewhere like France or Italy. Next slide, please. So just moving on to look at the EEA and EFTA countries. So pre-Brexit, these countries had the same rules that I just discussed for EU, assignments. So those people that are already working in those countries by the 31st of December can continue with the old rules and potentially get an A1 for up to 5 years if they're working temporarily. But post-Brexit, each EEA country, and Switzerland has slightly different rules in terms of the social security coordination with the UK, so you'd need to look at each separate agreement. The main points for each of those countries are up on the slide, but Switzerland, Iceland and Norway all do allow A1 certificates for a period of time, although it varies from 1 to 3 years and has some particular criteria for some countries. However, the main point to note on that is, maybe it doesn't come up too often, but we don't actually have an agreement at all with Liechtenstein. So that means that social security would be due under the new rules now as soon as an employee goes to work in Liechtenstein, and they may be required potentially to also pay UK national insurance for the first 52 weeks from departure. That rule applies where the employer has a place of business in the UK. The employee is ordinary resident in the UK and was living in the UK immediately before starting the work overseas. Next slide, please. So moving on to look at other countries outside of the EU and EEA. So those countries are split into those with which the UK has a social security agreement and those with which we don't have a social security agreement. Firstly, for employees working remotely in a country with which we do have a social security agreement, so for example, the US or Japan, social security is normally due in that country immediately with no UK national insurance continuing, unless that employee is on assignment. So again, if they're working on a short-term assignment in that country with which we have an agreement, it is possible to get a certificate of coverage to remain in UK national insurance. And usually those terms are up to 5 years. If your employee is working in a country with which we do not have a social security agreement, then there may be a continuing liability to UK national insurance for the first 52 weeks overseas, a bit like I discussed previously for Liechtenstein. And that means that there can also be local contributions due, which means it is possible that there may be double contributions for a period of time. Next slide. Lastly, I'd just like to have a quick look at how any UK work days will be treated for individuals that are based now working overseas and maybe returned to the UK for some work days. Looking first at the EU multi-state worker rules, so those have continued largely as they were pre-Brexit. So that means that if your employee meets the criteria to be considered as a multi-state worker under those rules, and that is broadly someone who is regularly working in 2 or more EU member states or the UK and at least 1 EU member state, they may be able to get a multi-state A1 certificate, and that will determine in which country they should be liable to pay social security, as it will be limited to 1 country only. That usually is where they are habitually resident, as long as they carry out a substantial amount of activity there, and that's defined as at least 25% of activity or working time. Otherwise, it usually ends up that they will pay where the employer is based. It can get a lot more complex in cases where there are multiple employments or a mixture of employment and self-employment. So that's an area where it's definitely best to look at the situation carefully. So for remote workers who are not multi-state workers, so for example, for someone who is usually now based working remotely in the EU but comes back to the UK for some work days and is not a multi-state worker, strictly an A1 certificate should be obtained from day 1 of working in the UK in order to confirm social security coverage in the other country, because that's a situation where they would normally be paying locally there. In practice, it had always been the case that for periods of kind of up to 4 to 6 weeks, it wouldn't be necessary to obtain an A1. However, post-Brexit, we understand that quite a few EU countries are enforcing the A1 requirement from day 1 quite vigorously in the reverse scenario. So we might expect that the UK might do the same. So it's always best to get the A1 in place to be sure. If you have workers working remotely in a country with which we have a social security agreement who return to the UK, again, they should have a certificate of coverage in place to cover the UK workdays strictly. If they're based in a non-agreement country where we don't have a social security agreement, then there will be no UK national insurance due for the first 52 weeks in the UK. And so there will be no requirements initially. That was just a brief look at some of the social security considerations for remote workers of UK companies. But I think the main point is to check each case carefully according to the facts to determine the correct approach. Our contact details are up on the screen if you have any questions that we can't answer within the webinar. And I'll just hand back to Tim.
Thank you so much, Charlotte. I'm conscious of the time. We probably have a couple of minutes to answer a couple of brief questions. So I think this one's probably for Charlotte, actually. How long does it take to obtain an A1 certificate?
That's a good question. So it used to be sort of typically around 6 weeks, but in the last year with Brexit and COVID, we've seen that being quite significantly delayed. And in more complex cases, it's been taking many months. So I would say get the application in as soon as possible.
We probably won't have a chance to cover all of these, but we'll follow on with them in the Q&A after the session. But there's probably one more that we have time for. This is probably for Jaouad. Due to COVID-19, didn't spend enough time in the UK. Does HMRC ease the restrictions or rules in terms of residence? Jaouad, I don't know if you've got any thoughts on that one.
Yeah, HMRC just provide like some guidance and saying that you need to follow the fact of the individuals and clearly check, as I mentioned before, the SRT. If you don't meet any criteria to be UK tax resident, basically you'll be not tax resident, and HMRC will not consider that the fact you have been basically in lockdown overseas, or you didn't come to the UK to spend some time in the UK, that will not consider as a fact that they will mention that you should be resident but you are not resident. So basically, compared to other countries like France, we will not consider like you have been on the same position that before COVID. So you need to have like follow the facts and the SRT. Thanks.
I think that's one of a number of concessions COVID related. There are quite a few in the immigration sphere as well. Right, I'm conscious of the time. It only remains for me to thank our panelists, Charlotte and Jaouad from James Cowper Kreston and Claire from BDB Pitmans, for giving us so much food for thought in relation to mobile workers. It's obviously a very complex area and there's a lot to give consideration to. And thank you very much for attending. As I mentioned, we'll be sending out the slides and the recording and hopefully the Q&A for any questions which we didn't mop up at the end there. If you have any ideas for events going forward, let us know. We'd be more than happy to give consideration to any suggestions. I was about to joke that I'm off to the beach behind me, but unfortunately the noise of the refuse lorry behind me is giving me away. So it only remains for me to thank you all for attending and to see you next time.